Moderna and the National Institute of Health, NIH, are in a legal tug-of-war. NIH claims Moderna didn't add 3 of its scientists to Moderna's principal COVID-19 vaccine patent applications. If NIH is correct, they would co-own any issued patents on a very valuable technology. Moderna's 2021 vaccine sales are forecasted to be $18 billion. NIH could own an equal, undivided interest in the patents, meaning they can do with them as they please. There are devastating consequences for failing to correctly name inventors. This can have a devastating effect on a patent's value. Let me give you a recent example. What I'm going to tell you about is a lawsuit. Ono Pharmaceutical Company learned the hard way that collaborations can be costly. Ono employees collaborated with employees of Dana-Farber, a Mr. Freeman and a Mr. Wood. They collaborated on a cancer treatment. It was a big deal. One of the inventors, Tsuku Hanyo, was awarded the Nobel Prize for the invention. 8 patents were issued to Ono, but none named Freeman and Wood. The lawsuit followed, and the court determined that they should have been named. Dana-Farber is now the co-owner of all 8 patents and is actively licensing the technology in direct competition with Ono. Yeah, I'll say it. Oh no! There's a link below to an article where you can read more about these devastating consequences. In the other link, I have a guide to help you determine who should be named as an inventor. It can be difficult to decide if there's more than one person working on an invention. Ultimately, your patent lawyer needs to make that decision with you. Red flags should always wave when working with non-employees. Collaboration between businesses is common. Each needs the expertise of the other. But if they don't have an agreement defining their rights, there can be unwanted surprises. Collaboration issues can also be hidden. When seeking the help of an independent contractor, it's a collaboration, and it doesn't have to be a product. It can be artwork, pictures, or other content, whatever is protectable. The best practice is to have a written agreement with any non-employee. This agreement needs to define who owns any patents, copyrights, or trade secrets, and what can be done with them. Unfortunately, in the NIH Moderna dispute, a spokeswoman for NIH said that none of their collaboration agreements with Moderna included language controlling the licensing of inventions that might result from that work. If there had been, there wouldn't be a tug-of-war. The takeaway: if you're working with non-employees, you need an agreement that clearly defines who can do what and who owns the results. If you currently are, or you're planning in the near future to work with non-employees, let's talk about how you can protect your interests. Click below to schedule a meeting. Thank you.